This event was planned by disability leaders from our sponsors and organizations, the University of Illinois UIC's Institute on Disability and Human Development, UIC's Disability Cultural Center, UIC's Women and Leadership and Resource Center, Disability Lead, National Network of Abortion Funds, the Chicagoland Disabled People of Color Coalition, and Planned Parenthood Illinois Action. We are excited and thankful to have you here. The fall of Roe versus Wade will have a disproportionate impact on disabled people, yet we are a community that is often left out of the discussion. Today, we will learn from experts and activists about the unique effects this issue will have on our community, our rights in Illinois, and how we can organize to take action. Before we get started, our U.S. Senator from the state of Illinois, Senator Tammy Duckworth, has a few words for us in this upcoming video.
Hi, everyone. I wish I could be with you all in person today, but I want to start by thanking you all for your work ensuring people, particularly women with disabilities, women of color, including Black and brown women and working women, all have access to high quality, affordable health care, including reproductive and prenatal care. This is work that has been crucial for years, but with the Supreme Court overturning Roe and states across the country, including our neighbors, banning abortion care, the critical importance of the work you all do will only continue to grow. We know that people with disabilities are not only less likely to receive contraception counseling and timely prenatal care, but they're also at greater risk for adverse pregnancy outcomes. And all too often, they lack access to healthcare facilities that have providers trained on their unique and diverse needs. In Congress, I have been pushing and prodding to ensure women with disabilities and all Americans can get the comprehensive, empathetic health care they need and deserve. For example, I helped introduce the Equal Access to Abortion coverage in healthcare, which would permanently reverse the Hyde Amendment and lift unjust abortion coverage restrictions for those who depend on Medicaid and other government-sponsored healthcare plans. And last month, my colleague, Senator Ameri, and I introduced the Reproductive Health Care Accessibility Act to help ensure women with disabilities get the informed care they need to have control over their own bodies. If signed into law, our bill would fund training for medical professionals who provide reproductive health care for people with disabilities, increase the representation of people with disabilities in the medical workforce, fund education programs focused on the sexual and reproductive health care needs of people with disabilities, and establish a new technical assistance center to provide recommendations and best practices regarding sexual and reproductive health care for people with disabilities. I'm proud to have helped introduce this bill to ensure those in the disability community, all 61 million of us, are not left behind in getting the care we need when we need it. I also voted to pass the Women's Health Protection Act to protect the right of all women, including women with disabilities, to make their own reproductive care decisions by formally codifying Roe v. Wade into law. But unfortunately, Republicans blocked this life-saving legislation, and we know their efforts are not about protecting life. If the anti-choice movement truly wanted to protect life, they'd be working nonstop to address the discrimination and barriers to full healthcare access that women with disabilities have long faced. They would be putting all of their efforts into addressing the growing maternal mortality crisis that has taken a tragic number of Black mothers' lives. They would be pushing for desperately needed policies that support parents, like affordable child care and paid parental leave, but they aren't. I'm proud that Illinois has some of the strongest protections for reproductive health in the country, and folks like you all are here to help people from across the Midwest. And our work continues. I refuse to let my daughters grow up in a world with fewer rights than I had. I won't stop working to enshrine Roe v. Wade into law and ensure reproductive freedoms are protected for all, regardless of disability, skin color, zip code, or income. Thank you all again for pushing for a better, more inclusive America.
Thank you so much, Senator Duckworth, for sending that in the video and for fighting for us in DC. We have a fantastic lineup of panelists, and rather than introducing myself, I will let them introduce each other. The panelists will present back to back, and we will have time for a question and answering from the audience at the end. Our first speaker will be Dr. Robyn Powell. Dr. Robyn Powell is an associate professor at the University of Oklahoma College of Law, where she teaches courses on family law, disability law, and professional responsibility, among others. She is also the principal author of NCD's Rocking the Cradle, Ensuring the Rights of Parents with Disabilities and Their Children. Dr. Powell is especially interested in intersection of disability justice and reproductive justice, and we are glad to have her expertise on our webinar.
Thank you so much for inviting me to participate in this presentation. My name is Robyn Powell. My pronouns are she, her, and I am a white woman sitting in a power wheelchair. I have brown hair and a green and white shirt. So before I talk about the experiences of disabled people and how, as we've heard, the jobs decision is going to disproportionately harm us, I want to just bring us back a little. And I would encourage us when we're thinking about these issues to really think about this from a reproductive justice perspective. I think that that is really critical as we're moving forward. And for those who are not familiar, reproductive justice is based on three key pillars. The first being the right to have a child, the second being the right to not have a child, and the third being the right to be able to parent one's child safely and with dignity. And so I say this because all of these issues are something that disabled people continue to experience oppression in. They are denied reproductive freedom across the board. So while abortion is one of the many areas, there are many. So when we're thinking about Dobbs and what we do from here, we need to understand the historical context. And to be sure, disabled people have been fighting for reproductive freedom for centuries. And that is not an exaggeration. We can see that in the late 1800s, the eugenics movement really took off. The eugenics movement was based on this notion that certain communities, including disabled people and other marginalized communities, should not be reproducing. And the eugenics movement really affected disabled people in three critical ways. The first being institutionalization, the second being forced sterilization, which gained the blessing of the Supreme Court in the 1927 Buck v. Bell decision, which I will note has never been overturned. And the third being marriage restrictions, that is laws that prohibited certain disabled people from marrying, or they only allowed disabled people to marry after the age of 45, which is because that is generally considered the reproductive age. So when we're thinking about how we got here and what the reproductive experiences are of people with disabilities, we need to remember that history and how the history is really deeply present even today in 2022. So abortion rights are critical for people with disabilities for a number of reasons, which I want to briefly outline. The first being, as Senator Duckworth alluded to, is disabled people, particularly multiply marginalized disabled people, experience pervasive reproductive health inequities. They experience significant rates of maternal morbidity and mortality. That is, they are more likely to die than their non-disabled people because of pregnancy-related complications. They're also more likely to have pregnancy-related complications, such as preeclampsia, early term delivery, and other kinds of things like that. So disabled people are experiencing really significant adverse maternal and child health outcomes. They're also experiencing other health inequities in other areas related to reproduction. So for instance, disabled people are less likely to have regular pap smears or testing for sexually transmitted infections. They're less likely to get breast cancer screening. So really, disabled people are already experiencing really significant health inequities. And I tell you this because rather than focus on taking more rights and more healthcare away from people with disabilities, we really need to be doing the opposite and trying to improve our healthcare. And abortion rights can be particularly helpful or important, rather, for disabled people who have other unique medical needs. For instance, if you are on certain medications, you typically have to wean off of them before you go through with a pregnancy. And if you have an unplanned pregnancy, which is fairly common amongst disabled people for a variety of reasons I'll talk about, then you haven't had that opportunity to wean off, and you are possibly, if you just stop taking them, putting yourself at significant risk. So we're really putting people with disabilities in a very difficult, and I would argue cruel position if we're forcing them to continue with unintended or unwanted pregnancies. The second reason why abortion rights are particularly important for disabled people relates to the first one. That is that disabled people have inadequate access to reproductive health services and information. Really, people with disabilities can't even access basic reproductive health care. Our OBGYN offices are inaccessible. They lack physical access. They don't provide any sort of sign language interpreters or any other communication access. They're just completely inaccessible to people with disabilities. And that also includes reproductive health information such as sex ed. We know that disabled people are less likely to receive sexual education. They're also less likely to be provided contraception. So all of these issues lead to poorer outcomes for disabled people. And again, we need to remember this. The third is that people with disabilities experience really extreme and severe economic disadvantages. People with disabilities are far, far more likely to live in poverty, to be economically disadvantaged, to not have adequate resources. And this is really important to understand because we see that the number one reason that people in general seek abortion care is because they feel they are not financially able to take on additional children or have any children sometimes. So again, we are possibly, if we're forcing people to continue with a pregnancy, we're putting them in even more extreme economic disadvantages. So we're just worsening this situation. The fourth reason that abortion rights are so critical for people with disabilities is that they experience substantially higher rates of intimate partner violence and sexual violence than other people. We can see that some studies have found that people with intellectual disabilities are 7 times more likely to experience sexual violence than non-disabled people. So again, this is a situation in which people with disabilities are being violated, and often that may result in an unintended pregnancy. And at the same point, we have to remember that those same people that are often the perpetrators of sexual violence are the ones that have control over whether people with disabilities are able to use contraception, or really reproductive coercion, where some people are forced to continue with a pregnancy they didn't want by their perpetrator, because we know that these perpetrators of sexual violence are so often caregivers and family members. And the fifth and final reason that I really believe that abortion rights are uniquely and critically important for people with disabilities is because of the challenges that disabled people have endured related to bodily autonomy and self-determination. For so long, we have been fighting for the right to just make basic decisions about ourselves, our lives, our bodies. We have fought this paternalistic viewpoint that we are not the experts on our lives. And we are finally getting somewhere with this. And by taking these abortion rights away, you are again just taking away our bodily autonomy and self-determination. So this is something that disabled people have been fighting for. And we need to continue to achieve this, not take it away. So then I'm the bearer of bad news, I often say, but I also do have some solutions I'd like to briefly mention because I think there is a way forward. So the first is we need to disrupt intersecting oppressions. Every poor outcome that I have mentioned is even worse if you are a disabled person of color or you are a LGBTQ plus person with a disability. So multiply marginalized disabled people are even more oppressed in this area, and they are experiencing the most significant reproductive oppression, the denial of their just basic reproductive freedom. And because of that, we really need to address these issues, not just from a viewpoint of ableism, but really looking at all types of oppression and how they intersect and cause these pretty significant and unique experiences. The second is that people with disabilities, they need to be centered as leaders in the movement fighting for abortion freedom and reproductive freedom moving forward. For so long, people with disabilities have been excluded from this discourse. And there's a number of reasons, one of which it's just we have a very difficult history between the reproductive rights movement and the disability rights movement. And there's this history that has caused really pervasive tensions in many ways. And instead of address them, the two different groups have sort of just avoided these issues. And we really need to bring disabled people to the table, and not just bring them to the table as sort of a token, but really promote them as leaders. They need to be included in all efforts moving forward. The third thing we need to do is really ensure that we are protecting autonomy and self-determination. And one of the ways that we do this is by abolishing guardianship. And for those who are not familiar with guardianship, we can look to the experiences of Britney Spears, who had a conservator, which is just another name for guardian. And while she was under the conservatorship for 13 years, she was subjected to forced contraception. And what happened to Britney Spears is common amongst many people with disabilities who are subjected to guardianships. And unfortunately, unlike Britney Spears, do not have a platform that Britney Spears did have. And so if it took Britney Spears 13 years to get rid of her conservatorship or guardianship, you can imagine that it's even more challenging for most people with disabilities. So we really need to move forward with moving away from these restrictive policies and instead looking at least restrictive policies such as supported decision-making, in which people with disabilities are afforded the opportunity to make their own decisions, and that we do so in a way that supports them. And we, instead of making the decisions for them, we help them so that they can ultimately make their own decisions. The fourth thing we need to do is, of course, we need to ensure accessible sexual and reproductive health services and information. Every part of sexual and reproductive health must be fully accessible to disabled people. This means complying with federal disability rights laws, and this does include abortion providers. We also need to ensure that people with disabilities can access abortion if they need to travel out of state. And so I've seen abortion funds start to really look at how they are providing transportation to individuals and is it accessible for people with disabilities. And I would encourage other folks to really think about these access barriers moving forward. And then finally, we need to ensure and guarantee rights, justice, and wellness for disabled people and their families. We need to ensure that people with disabilities are in a better economic standpoint so that they have ultimate choice, that they don't feel pigeonholed into some decision. We need to ensure that they have all of their transportation needs met and all of their other determinants of health met so that they can make decisions that they believe are best for them while also having the right resources available to them. And we also need to do things like Senator Duckworth mentioned, getting rid of the Hyde Amendment. We know that most people with disabilities are Medicaid beneficiaries, and we know that federal funding cannot go towards abortion, which means we are really limiting people with disabilities access to abortion services. We need to ensure that Medicaid covers abortion services. We need to ensure that we are passing legislation expanding access to abortion and other reproductive health care, and ensuring that disabled people receive sexual education, contraception, and everything else they need so that they are able to make the best decisions for themselves. And so with that, I am going to end and thank you all again. And I believe I'm now passing this on to Ameri Klafeta.
Thank you very much, Dr. Powell. Hello, my name is Ameri Klafeta. She, her pronouns. I am a white woman. I have shoulder length brown hair, brown eyes. I'm wearing a black jacket and a patterned top. I'm the director of the Women's and Reproductive Rights Project for the ACLU of Illinois. One of our core priority areas here at the ACLU of Illinois is to work to expand and protect access and reproductive rights, access to healthcare and reproductive rights here in the state of Illinois. It is really my pleasure to be here to be able to paint a little brighter picture and talk about where things stand in the state of Illinois. If you are familiar with the maps that have depicted the 26 states that are likely to ban abortion, when the dust settles from the Dobbs decision, then you'll know that Illinois sits right there in the middle of the country, a little island with a sea of states surrounding it that are very hostile to abortion rights. And most of those states already have abortion bans that are in place. This wasn't always the case here in Illinois. For many decades, we had terrible laws regarding abortion that were getting passed, that were on the books here in Illinois. And for decades, going back to the 70s, here at the ACLU of Illinois, we have been in court fighting back, trying to block those bans from going into effect, trying to keep abortion restrictions from hampering the health care that abortion providers are providing, and that we're making it very hard for people to get care. And we've heard the Hyde Amendment mentioned. Of course, Henry Hyde also hailed from the state of Illinois. So from decades of fighting back, we actually were in a pretty good place. We had some pretty good law here in Illinois regarding abortion care, but it was as a result of all of these court orders, all of which, turned in large part on the protections of Roe versus Wade and the 1992 case that reaffirmed Roe, Planned Parenthood versus Casey. So, as the 2016 election came upon us, we really began to worry. Trump had campaigned on putting justices on the Supreme Court who would overturn Roe. And we worried, what did that mean for all of these court orders that we had that were holding back all of these really terrible abortion restrictions in Illinois? At the same time, the political climate had changed here in Illinois. So after the election in 2016, we were able to shift our approach from fighting in the courts to hold off these abortion restrictions to working in the legislature here in Illinois to get proactive legislation passed regarding reproductive rights. And I'm going to walk through 3 pieces of recent legislation that have helped us prepare here in Illinois for the post-Roe, post-Dobbs world that we are now in, which are really important for making sure that both people in Illinois can access reproductive health care, and also, unfortunately, people who can't access this care in their own state have a place that they can come to get the reproductive health care. So the first of the 3 measures was HB 40, and that was signed in 2017. This was a law that was actually signed by Governor Rauner, and it did 2 main things. It removed trigger language that was in Illinois that would have brought back old abortion bans if Roe fell. So I'm sure people are familiar with the trigger bans. Those are what have gone into effect in many states. They kind of came back on the books automatically with Roe being overturned. We had one in Illinois, and HB 40 took that off the books. So that was our first level of protection. The other really important thing that HB 40 did was extend Medicaid coverage to abortion care. So the Hyde Amendment prohibits federal funds from being used for abortion care in most situations. Here in Illinois, the state uses its own funds to provide Medicaid coverage for people who are seeking care. And that has really been a game changer for people here in Illinois. We went back to the General Assembly in 2019 and went to Springfield, and then had the opportunity to go back and do a lot more comprehensive legislation with regard to reproductive rights. So that was when we passed the Illinois Reproductive Health Act. And this is groundbreaking legislation. It is the only legislation of its kind, certainly in the Midwest, and very few states have legislation that is this protective. The Reproductive Health Act did 3 things. First, it codified Roe into state law, so there is a right to an abortion that is clearly spelled out in Illinois law. The second thing that it did was remove a lot of archaic language from our books. So all of these bans that had gone into effect, all of these old provisions, for example, we had a spousal consent provision that was still sitting on the books. They've been blocked by courts, but they were still sitting out there. So the Reproductive Health Act took all of those off the books. It replaced it with a very modern law that ties regulation of to medical standards and evidence-based practices, and establishes a fundamental right for people to make their own decisions about this reproductive health care. And I will talk, I'll finish going through, the rest of the legislation, and then I'll talk more specifically about what the Reproductive Health Act did and what that means in particular for disabled people. But the third thing that the Reproductive Health Act did was require private insurance coverage of abortion care. So if a private insurance plan that is issued in Illinois covers pregnancy-related care, then it must cover abortion care as well. After the Reproductive Health Act, we had one remaining obstacle to abortion care that was still on the books that didn't get cleaned up with the Reproductive Health Act in 2019, and that was our Illinois Parental Notice of Abortion law. So in 2021, legislators went back to Springfield and they repealed that law. That was through the Youth Health and Safety Act. And people may be familiar with, in the last couple of weeks, there was a news story that was getting a lot of attention about a young woman in Florida who Florida had a parental involvement law, and she sought a judicial bypass to go ask a judge for a waiver of the requirement to notify her parents, and the judge denied the judicial bypass because her grades weren't good enough. That's something that could have happened here in Illinois a year ago had we not repealed the parental notice of abortion law. We know from research that young people who can safely involve their parents in their abortion decision will do so. And those who don't have very good reasons. And the law was really just putting young people who are not in good family situations and safe home situations in danger with the law. And that law, the Youth Health and Safety Act, in addition to repealing the parental notice law, also established a working group to take a closer look at the needs of pregnant and parenting youth. So to go back to the Reproductive Health Act, that's really what has set the stage for the regulation of not just abortion, but reproductive health care here in the state of Illinois right now. It protects autonomous decision-making around reproductive health care. And reproductive health care is defined very broadly. So it is not just the right to have an abortion, it is the right not to have an abortion. It is the right to refuse or to use contraception, to give birth, to make one's own decisions about maternity care, about what childbirth looks like. And these are all fundamental rights. If there is any sort of governmental interference with these rights, then the governmental interference will be invalid under the Reproductive Health Act unless it meets a very high standard. For it to be upheld, it's got to be consistent with accepted standards of clinical practice. It's got to be evidence-based. It's got to be narrowly tailored for the limited purpose of protecting the health of the person who's seeking the reproductive health care, and in the manner that least restricts their autonomous decision-making. So it puts a lot of protection around individuals' ability to make their own decisions in conjunction with their healthcare providers. As Dr. Powell talked about, people with disabilities have long been denied control over their own bodies and have fought against paternalism and stereotypes, including their ability to consent to reproductive health care, their ability to understand medical information. And the RHA really protects decision-making around reproductive health care from this kind of paternalistic governmental interference. We also know that disability is a very broad term that could mean a lot of things. And by centering decision-making on accepted standards of medical practice, it allows people to make the best decisions for themselves with their healthcare team, taking into account their own circumstances, their own needs, their own situations. And again, that would be the case for making decisions around contraception, abortion, medical care during pregnancy. Disabilities may complicate pregnancy, and as a result, bans on abortion that restrict the point in a pregnancy at which the decision could be made can rush people into decisions about whether or not to terminate a pregnancy, often before they may be able to get a complete picture of the risks and the challenges associated with the pregnancy. Under Illinois law, abortion is protected until the point of viability, which is around 24 weeks or so. So unlike states that may have abortion bans earlier in pregnancy, Illinois law protects the right to make a decision about abortion up until about 24 weeks. After that point, abortion is still available in Illinois if it is to protect the life or health of the pregnant person. The Reproductive Health Act would, of course, also extend to a situation where someone may feel coerced into a labor induction or a C-section, for example. The Reproductive Health Act prohibits the government from penalizing or punishing someone based on their conduct if the purpose of the punishment is to penalize the pregnancy outcome. And so that would apply, for example, in a case where someone was being told you must agree to a C-section or you'll be referred to DCFS, for example, or something like that. And then the last issue that I'll just mention is the issue of forced sterilization. The Reproductive Health Act would protect autonomous decision-making on this front as well. Illinois does have a forced sterilization law under the Probate Act of 1975. Under that act, a legal guardian can petition for sterilization of a ward if the court determines that the ward is incapable of consent and it would be in the best interest of the ward. I think that there is a lot of tension between how that provision would be interpreted in conjunction with the Reproductive Health Act. That would be an open legal question. There's only been one reported case under the law, and the sterilization was denied because the court determined that there were other contraceptive solutions available, but that case was from 2008, which is not really that far in the distant past. So, that is an overview of Illinois law. The thing that I would like to close with is just to say, I think it is really important that here in Illinois, we don't take for granted what we have. We are very fortunate that we've had lawmakers go to Springfield to get this legislation passed and to get this work done to protect people in the state and to demonstrate that in Illinois, we trust people to make these decisions for themselves. But every time we have good legislation get passed in Illinois, there are lawmakers who are ready almost immediately on the other side, ready to introduce bills to overturn the legislation that we just got passed. Every time we get a good bill passed, we see challenges in court. The Reproductive Health Act is being challenged right now in court in Sangamon County. For example, this is an election year in Illinois, as I'm sure everyone knows. There are races up and down the ballot that includes 2 Illinois Supreme Court seats. So as our good legislation gets passed, when it gets challenged in court, it's going to go up through these same courts. And so it's really important for people to continue to engage. Let your legislators know that you appreciate what you've done for them, stay involved in the political process. Talk to your friends and family about who live in the suburbs where the Supreme Court race is on the ballot, and just stay engaged so that we can protect what we've done here in Illinois. So thank you so much for having me, and I will now pass over to Cristina Headley from Equip for Equality.
Hi, everyone. Thank you, Ameri, and thank you for our organizers for putting together this important event. I use she, her pronouns to describe myself. I'm a white woman wearing a black collared blouse. I have above the shoulder brown length hair. Behind me is a gray background with a green star in the upper right corner of the screen with the words Equip for Equality wrapped above and below it. I am an attorney at Equip for Equality, and we are a civil rights organization for people with disabilities in Illinois. We provide legal services, legal advocacy services to people with disabilities in many areas, including access to healthcare and self-determination, which are very important to our discussion here today. People with disabilities are often included from these conversations about reproductive rights and care. And we find that this exclusion is based on several false assumptions. And those include that people with disabilities should not and do not have sexual lives, that people with disabilities cannot or should not reproduce, and that people with disabilities are not able to make their decisions about their own bodies, and that they need others to make those decisions for them. And these assumptions show that people with disabilities really do need to be part of these conversations. The clients that we work with, they come to us with problems that show they are just like everyone else, and they have the same concerns and wants and desires for their lives. They have sex, they have a desire for relationships, they want to have children, and they want to have abortions. Fortunately, abortion is legal in Illinois, but unfortunately, as many of the speakers have talked about so far, people with disabilities in Illinois disproportionately experience disadvantages that may increase their need for abortion services, even more than anyone else. I'm going to focus on talking about 3 different issues or areas which may increase or affect an individual's need for abortion services, and some issues that clients come to us with and we work to address. So the first that other speakers have talked about today too is that individuals with disabilities face many different barriers in accessing and receiving healthcare. And these barriers result in them having unequal or inadequate access to healthcare services. We've represented clients who are deaf and whose medical providers will not provide them sign language interpreters for appointments. As a result, they are unable to effectively communicate with their doctors and understand their conditions and available treatments. We've also seen individuals with physical disabilities who get to their appointments and find that they cannot get on an exam table because it cannot be lowered far enough below to a height where they can transfer from a wheelchair. We've also heard from clients who tell us they have been told they cannot bring a service animal to a medical appointment. In addition, many clients come to us who are denied access to treatment from their Medicaid MCOs. All these issues represent extra burdens on people with disabilities, which affect their health and their access to care. Like Senator Duckworth and Dr. Powell previously mentioned, in order to address these issues, the Americans with Disabilities Act prohibits medical providers from discriminating against people with disabilities. And these need to be enforced more, and education in the medical field of these requirements needs to be increased. In addition, as been previously mentioned, Medicaid coverage should be expanded. The second issue I want to touch on is how access to abortion is also critical for people with disabilities because they sometimes have a higher need. This is due to higher rates of maternal mortality and serious health risks that they may experience from pregnancy. People with disabilities are more likely than non-disabled people to experience sexual assault. This is according to statistics from the Bureau of Justice Statistics. This likelihood, is also increased for people who have multiple disabilities. And this happening can be linked to how people with disabilities lack access to information about reproductive health and healthy relationships. Information that should be provided includes their right to body integrity, their right to privacy, and their right to personal choice. and their right to treatment planning that supports their rights to sexual health, healthy sexual practices, and to be free from sexual exploitation and abuse. There is a law in Illinois that was put in place within the last few years that requires residential and vocational service providers to individuals with intellectual and developmental disabilities to provide appropriate sex education in these areas to their participants. We have yet to see evidence that this law, however, is being implemented and largely adhered to. So we think that this law needs to be followed and needs to be enforced further. The third area I want to talk about is guardianship, because this is another area that prevents people with disabilities from exercising their full reproductive freedoms. In Illinois, a court can appoint a guardian over an individual where it is shown that because of an individual's disability, they're unable to make responsible decisions about their care or their finances. If an individual has a guardian over their healthcare decisions, then that person can have the authority to make decisions about contraceptives, abortions, sexual education, and who the individual communicates or interacts with. Under Illinois law, guardians are supposed to make decisions according to an individual's expressed preferences, unless that preference is likely to cause substantial harm to the person's welfare. Unfortunately, we see many situations where guardians don't follow this requirement and really overstep their boundaries. For instance, we've seen guardians who, after learning that an individual with a developmental disability was in a relationship with their roommate in the home that they lived in, their SILA home in the community. SILA home is a community integrated living arrangement. The guardian, after learning that the individual who they had guardianship over was in a relationship with a roommate and was having sex, they threatened to move the individual to a different home against their wishes, even though, they were informed that the relationship was consensual and they, wanted to be in this relationship with this individual. We've also seen a situation where a guardian attempted to obtain an order of protection against another resident after learning that they were in a relationship and having sex with the individual that they had guardianship over. And if this would have been put in place, this would have had the effect of evicting the individual from their home. So, the effect of guardians overstepping their bounds can have a great effect on individuals' lives in these areas, obviously, that we've seen. So in addition, without access, if the situation became where access to abortion in Illinois, was restricted, we would be concerned that guardians may become fearful that their wards will get pregnant and not have access to abortion. And they may try to get their wards sterilized or try to restrict intercourse to prevent pregnancy. While, as was just mentioned, Illinois law does have strong procedural and substantive safeguards in place, which requires a guardian to obtain permission from a court before authorizing sterilization. We would be concerned that sterilization is not a practice that we want to go back to using widely. Sterilization irreversible medical procedure in most women. It's pretty invasive, as one needs to be sedated, and can have profound physical and psychological effects if it is performed against an individual's will. So in summary, a number of these topics I could go on speaking all day about, but we wanted to raise these stories from, some of the barriers that individuals face that we worked on, and the importance of protecting the right to abortion in Illinois and expanding access even to individuals with disabilities because of their increased need in some of these areas. Now I will turn it over to Keidra Chaney with the National Network of Abortion Funds, where she works as a digital engagement and accessibility manager and disability and reproductive justice expert.
Thank you, Cristina, and thanks everybody for having me today. As Cristina said, I'm Keidra Chaney. I'm the Digital Engagement and Accessibility Manager at National Network of Abortion Funds, or NNAF. My pronouns are she, her. My visual description is I'm a Black woman wearing red cat eye glasses with an Afro puff, and I'm wearing a Black shirt that says everyone loves someone who had an abortion. And I am sitting in my working space / kitchen. Today, I wanted to talk from my perspective as a disabled Black woman that's working in reproductive justice, especially since the weeks and months since the Dobbs decision, and also talk tactically about what some of the things that folks can do now to take action in this moment along those intersections. Right now, with the fall of Roe and also during a mass disabling pandemic, I've noticed a shift in perspective from the general public and also from the media who are experiencing and witnessing more barriers in their own healthcare, be it reproductive or other types of healthcare, or witnessing those experiences from their friends and loved ones. And because of that, the general public is able to talk about and acknowledge and identify barriers to healthcare that folks haven't always been willing to acknowledge or feel comfortable with acknowledging publicly. Dr. Powell earlier outlined the pillars of reproductive justice: right to have a child, right to not have a child, right to parent a child with dignity and in a safe environment. And I wanted to connect those pillars of reproductive justice with disability justice because there's a lot of similarities. Both disability justice and reproductive justice are frameworks that highlight bodily autonomy and self-determination, and both disability justice and reproductive justice highlight how race, class, gender, and other segments of identity intersect in people's lives, and how access to healthcare is shaped by those different intersections, whether it's racial healthcare inequities, healthcare inequities faced by LGBTQ+ people, bias from medical providers, sexual violence, poverty. And when it comes to abortion care, state and federal restrictions on abortion that like insurance coverage bans, crisis pregnancy centers that mislead people about their reproductive care options, government mandates, all these things add to the delays that disabled people face when accessing abortion care and reproductive health care. The disability justice and reproductive justice acknowledge the limits of the law and legality in achieving true justice for all. You'll hear a lot of people in reproductive justice movement talk about how Roe v. Wade is the floor, not the ceiling. And you'll see similarly folks in disability justice talk about how the Americans with Disability Act is the floor, not the ceiling. Legal rights are the start, they're crucial and important, but they're also the minimum of what people need for full access to healthcare and to justice. So in my work at NNAF in the past month, I've seen a real desire from newer supporters who want to do a lot more on the ground work in both reproductive justice and disability justice and not really knowing where to start. I'm seeing more people who want to work more directly in helping abortion seekers navigate these barriers, more than just writing a check or attending a protest, or in addition to doing those things. And so in addition to political mobilization, there's also a robust and informed ecosystem of abortion access in this country, support that has been, folks have been preparing for this moment for decades now. And I wanted to talk a bit about this ecosystem and outline some of the players in it. You might have heard a lot about abortion funds in the past few months. I think in the past, post-Dobbs, abortion funds have become the new hip thing for folks. They're not new. Many abortion funds have existed for a few decades now. Abortion funds are grassroots organizations, mostly volunteer, that work to remove financial and logistical barriers to abortion access. And they do this in a few ways. Some funds will work directly with a clinic to help pay for, finance people's abortions. Other funds do something that's called practical support in terms of offering and supporting transportation, childcare, language translation services, doula services, or offering a place to stay for folks who have to travel to get their abortions. Right now, there are over 90 organizations in NNAF's networks and several organizations that aren't in NNAF's network, but we also work together across the country, even in states that have current abortion restrictions and bans. Many abortion funds in those states are still active, but there are many who've had to shift or scale down their support work in response to state abortion bans. What we do at NNAF is provide infrastructural support, such as helping with legal defense fees and resources, offering technical assistance, like helping organizations deal with online harassment and data privacy issues. And a lot of this work is very state and local based right now, and more challenging than ever due to the threat of criminalization. So it's a challenging time for us, but it's really important for people who do want to get involved to know that getting connected with your state abortion fund is really more important than ever, because in many cases, these are the folks that know what's best about what's going on, what's happening in the ground for people actively seeking abortion care in your state. You can find your local abortion fund at abortionfunds.org, or you can go to ineedana.com and locate independent clinics and funds in your area, which I highly recommend. Here in Chicago, for example, we've got the amazing and mighty Chicago Abortion Fund that does amazing work, and Midwest Access Coalition that also does amazing practical support work for not just Chicago, but for folks that are traveling from neighboring states. Apiary for practical support is an important place to go for people who want to do hands-on work with client intake, hosting, and transportation. There are also abortion doulas. Abortion doulas are individuals who are trained to help provide emotional support and information for those who are navigating abortion, anything from holding someone's hand, helping with aftercare and recovery. ProjectNia.org here in Chicago is doing abortion doula training right now for BIPOC folks. That's happening later this fall. And there's also abortion or doula training guide for anybody who's interested in abortion doula or dueling work overall. There's clinic escorts that help assist patients at abortion clinics, welcoming them, helping them get in and out of clinics safely. Choice Action Team in Illinois is a great example of a place that trains clinic escorts. There's national abortion storytelling organizations such as We Testify and Shout Your Abortion that help train people who want to publicly share their own abortion stories, either to the media or hearings, to help counter misinformation and bust abortion stigma, and also just educate folks about their personal experiences in accessing care. Digital Defense Fund, if you have tech skills, it's really important right now. Security and data privacy is a crucial issue right now for folks who are helping folks care. If you're a lawyer, If, When, How is an organization that you can plug into. These are all organizations that work together in collaboration with each other, and they all would benefit from the insight and expertise and voices of disabled people. Dr. Powell and Ms. Headley said firsthand, talked about like that the reproductive rights and justice movements haven't been accessible or inclusive of disabled people over the years and decades. And I've experienced that firsthand as well. Still using eugenicist rhetoric or ableist language or assumptions in their communications, ignoring the access needs, of abortion seekers and disabled folks within the movement as well. And I think we need more voices to call out this entrenched ableism and more people within reproductive rights and justice to directly address the challenges and barriers that disabled people face in abortion access. For example, and this was mentioned by many of the speakers earlier, advocating for better physical access in clinics for people